Ruth Dyson, 5
Thanks very much, Mr Speaker. I just want to commend the member who's just resumed her seat for her contribution to this debate and say to the member from New Zealand First who spoke immediately before her that I think he should have listened to her contribution and figured out that actually the law as written in 1998 did not make it clear that the way it was operationalised after that was in fact the intent of the law. Nothing in the Hansard's records would lead one to assume that that was the case. But I don't think that there was a deliberate attempt either by the minister of the time. Who was the minister in 1998? Okay, I can't recall who the Minister of Social Welfare was in 1998, but I don't think the Minister of the time or the current Minister or the department has made a deliberate decision to underpay beneficiaries, to start people getting their benefit a day later than they were intended. This is an error. This is a legislation interpreted 18 years later in a different way than it had been implemented. So that isn't the challenge for this House to debate, in my view. The challenge for us is to say, how should we fix what has been determined through the appeal process as a misinterpretation of the law? So of course you have to either say, well, we're going to change our operation or we're going to change the law. The minister's decided to have a bob each way, and that's where I disagree with her. I think that it's fair enough for her to take a call as the minister and say, well, we'll start the payment the day after the stand down ends, or we'll do as we have been doing, or we'll start it as the original law intended, leave the law as it is and start it on the last day of the stand down. That's the difference. That's where the 1 day comes from. But to then say we're going to change the law to the way it has been interpreted, which is leaving all those beneficiaries with a day less of their payment than they would have had if it had been interpreted the way that it was intended, to retrospectively take that off them is unfair. It's saying we interpreted the law wrong for 18 years. We found out 15 months ago that we were doing it wrong, but we're going to retrospectively take that entitlement off how many people? We don't know. It could be thousands, it could be hundreds. The Minister, Anne Tolley, sort of dismissed it on a radio interview that I heard. She said, oh, it's only a day, and so it won't be very many. Well, actually, over 18 years, it could be quite a lot. Teacher aides, for example, if they're employed term by term, may be on a stand down 4 times in 1 year. And over 18 years, that's quite a few days' payment that they would be entitled to. But the Minister has said, oh, we've got to balance, changing the law with financial responsibility. Well, I say, actually, our job is to comply with the law or to change it, but not to change it retrospectively to suit what? The budget? Convenience. People were left out of their legal entitlement because of a misinterpretation, and I don't think they should have that 1 day's pay from their benefit taken off them by a retrospective law change. So that's where I strongly disagree with the determination that the Minister has come down on. Retrospectively taking away an entitlement is bad law, it's unfair, it's wrong, and I wouldn't want my name to be marking alongside it. And I don't understand, if it's so few people, as the Minister has said, why she's happy to go along with it. So, Mr Speaker, I think we should stick to the facts of this case. The idea that some have raised that, there might be worthy beneficiaries and not, I don't agree with that at all. I think that's a disgraceful slide into value judgments that isn't appropriate for this Parliament. The idea that Parliament should only fix a misunderstanding from the day that it discovered it is just plain nonsense. The courts would never do that. The courts would never say, this is our determination and from now on you'll interpret it. The courts operate in a way of interpreting our law from the time that law has passed. That's the standard that is set by our judicial system, and I think it's a standard that this Parliament should follow.